Infringement of competition law costs business consumers billions of euro each year. It's long been accepted that individuals harmed by a breach of competition law have a right to damages. But for many years, the issue of private enforcement of EU competition law has been very much asleep. Despite initiatives at EU level, the process has moved much slower than expected. The title of this presentation is Private Competition Law Enforcement in Europe, The Sleeping Beauty Awakes. For many years considered to be dormant, there has now been various initiatives that signal a much more effective enforcement regime, both at EU level and national level. Today I'm going to focus on the changes that have taken place over the last decade or so. And it's helpful to roll back a few years to 2008 when Neelie Kroes, the then European Competition Commissioner, commented, almost lamented on the state of private enforcement at that time. She emphasised just how hard the Commission was working in terms of advancing consumer interest, but recognised there were real shortcomings in the system as to how individuals and businesses affected by a competition law breach might seek individual redress through the courts. Since then, there have been white papers, green papers, and further impetus for action. And this really came to a head in June 2013 when Almunia, Vice President of the European Commission responsible for competition policy, unveiled plans for a new directive on private enforcement. And this was intended to set the minimum irreducible standards on procedure, on evidence, which were to apply at the national level, and to pave the way for a more effective regime for private enforcement. As we speak, the proposals are being viewed, consulted on, and a compromise position has been agreed on. And the years to come will really define whether EU competition law enforcement can in fact come of age and give individuals effective right for redress, in individuals including consumers and business. To put this in context, I'm going to consider first of all the antitrust enforcement options. What are the options available for parties who believe they have been harmed by a competition law infringement? I'm going to look in more detail at the EU and UK reform agenda in this area, and then conclude with some thoughts on the remaining prospects and challenges for private enforcement. So let's take a step back and look at the types of cases which may be suitable for a competition law remedy. The standard case is a cartel, a price-fixing cartel where the default position what is expected in a competitive market is that parties will individually agree prices. When they agree prices or agree which customers they supply or at what prices they will sell, that is typically called a cartel. And cartels remain the most high-profile area of enforcement by the regulators. That typically results in fines up to 10% of turnover. But where individual customers may be paying above the competitive price, a fine and a commitment by the parties to stop the infringing activity may not be active redress, where what they're seeking is damages for the overcharge that they have been paying. And that's where the prospect of private enforcement action before the courts to pay damages can be a powerful deterrent effect or redress mechanism for those parties who have been harmed. Let's turn now to a second type of antitrust infringement, abusive dominance. Let's look at this in the context of perhaps a complex distribution system. It may involve in intellectual property, it may involve technology. What is a particular characteristic of technology markets is the way in which control over one element of the supply chain, it may be an operating system, it may be hardware, may lead to an extension of market power through to software, application and content. A so-called leverage of market power, where whoever controls an important input along that distribution chain has the ability to exclude third parties who need access to that supply chain to supply their own services. If one party refuses to deal, what are the options? Well, a complaint to a competition authority could result in a mandatory injunction, an award, a decision that there will be a supply in that context. But that remedy may not come quickly enough to prove as a viable commercial remedy. It's an example of a case where action before the courts, maybe for damages, for the foreclosure, the denial of access to the market that has been suffered in the period of refusal to supply. It could be an injunction requiring for resumption of supplies. So another situation where private action before the courts can be an effective remedy. Let's turn now to perhaps a more complex scenario. This takes place in the context of perhaps privatisation of a former government-owned utility. There may be a prospectus issued inviting investment in a business which was formerly controlled by the state. What happens if there are supply agreements attached to that? What if the entity, before it is sold off, needs to buy services from the market? What if customers, competitors, investors feel that the procedure has been conducted improperly? Well, there are various options here that might be considered. In circumstances where the government might have a preference to buy national, the EU rules on public procurement operate to seek to establish a level playing field. But quite often, when those procedures are not followed, competitors who are aggrieved by the procedure may issue their own action before the courts, seeking damages and seeking for the procedure to be annulled. It's another example of a situation where there may be remedies and procedures at EU level, but where individual parties who are harmed may have options before the courts. So a very rich, multifaceted enforcement regime where the decision between whether to make a complaint to a regulator or launch your own action before the courts involves many complex issues. Let's now consider the pros and cons of making a complaint to a competition authority. On the plus side, a competition authority like the European Commission or the Office of Fair Trading, as it was, and now the Competition and Markets Authority in the UK, typically deals with these types of cases and has a wealth of expertise in looking at similar issues. The authority may have investigatory powers, typically to launch a dawn raid, which is an unannounced inspection visit, which can be very useful in procuring relevant evidence. And once the authority finds that there has been a violation of competition law, that decision can be very useful in terms of bringing follow-on action before the courts, where it is considered to amount to evidence of infringement. That is currently the position in respect of decisions of the European Commission. The status of decisions at national level will of course vary by the jurisdiction concerned. Another issue is costs. Costs will always be an issue in fighting anti-competitive practices. But once a complaint is made to a competition authority, the investigation is at the cost of that authority. Obviously, the extent to which a complainant wants to be involved in that will drive its own costs and other strategic considerations, but the bulk of the costs will be borne by the authority. There are some downsides. If the complaint is successful, the remedy will typically be enforcement action by the authority in the form of fines against the infringing company. It won't be damages in the pocket of the complainant. It can sometimes be rare for interim relief to be awarded by a competition authority, which means that during the currency of the investigation, the party who is aggrieved may have to suffer under the effect of the alleged anti-competitive practices. There may be greater prospects for interim relief in terms of termination of the practices in the event that private enforcement is pursued. A complainant before a competition authority, depending on the procedure, may have fewer rights in terms of control of how the procedure is conducted. Where it is launching litigation, it will be more in the driving seat. And again, issues as to the applicable law, where a complainant makes a complaint to the European Commission, EU law will be the governing law. A complainant who wants to pursue private enforcement may have a richer range of options in terms of the relevant law, depending on which national regime it launches its action in. Where that is EU law, typically EU law as well as national law will apply and will be very similar, but there may be certain benefits that can be exploited where the national rules are more favourable. But there are also some practical issues about making a complaint. There is a wide category of complainants, both to the European Commission and national authorities, but the aggrieved party must show that they've got a legitimate interest in making the complaint. Typically, they are a competitor or a customer or supplier to that party who has been harmed by the practice. There is an issue on how to get the authority interested. Certainly at EU level, the question of there being a union-wide interest for practical purposes will be a real issue for a complainant, and it is often in the complainant's interest to set that out in any submissions and complaints they make to the Commission. Other factors in terms of the duration of the infringement, whether it is continuing, the extent of it, and also the probability of being able to secure evidence of infringement will be relevant issues in trying to persuade an authority to take up a case at all. And what evidence is required? The more that a complainant can put before the authority to make their job easier will obviously be an important driver of the case. But clearly setting out the facts that give rise to the concern, relevant market effects, even economic evidence can be very helpful in terms of bolstering up a complaint. Further issues to consider from a very practical issue is, what is the desired outcome? What does the complainant want to seek? Do they want the practices to stop? If this is activities such as predatory below cost pricing? Do they want supplies to resume if it's an issue of refusal to supply? So setting out the remedy that you are seeking is very important, and it's actually required under the Form C that has to be submitted to the European Commission in order to make a formal complaint. The role of the complainant will vary depending on the case, and a lot depends on whether that complainant has formal complainant status, which has been granted following their complaint. As a minimum, such party would have the right to receive and comment on a non-confidential version of the Commission's statement of objections, which is essentially the charge sheet that the Commission lays out to the allegedly infringing undertaking. And the third party will have an opportunity to express their views at an oral hearing if there is one. What if the complaint's rejected? There is no obligation on the Commission or a national regulator to take a complaint the whole way. If a complaint is rejected, the complainant will consider whether it might have action by way of judicial review against a decision to reject the complaint. It may want to consider its options before other authorities, which may take a more benevolent view or be more interested in the complaint because it engages their market. And it's by no means unusual for complainants to make multiple, even parallel complaints to different authorities to maximise their chances that an authority that's best placed will take up the case. There are, of course, guidelines as between the European national regulators and the Commission, and it may be that a case is repatriated to a national authority or authorities or the Commission, depending on which authority is best placed to deal with that. Let's now turn to the issue of private enforcement. So what might make private enforcement a more viable, attractive option? Well, almost a mirror image to some of the drivers that have been considered in relation to complaints to an authority. So party-led. An advantage in making an action before the court is the fact that the litigant, the claimant, will have much more control over the action. Damages would be a usual remedy to seek in this instance, and injunctions where those are available. A private litigant, again, depending on the nature of the practices that are at issue, the situation of the defendant and the claimant themselves, where the damage is suffered, they may have a much wider choice in terms of the venue where they'll make their litigation. And again, there may be more flexible options in terms of the relevant procedural law, but also the substantive law, which can raise quite complex issues from a conflict of law perspective, which again gives opportunities for forms of arbitrage in terms of litigation strategy. Let's look now at the downsides. Well, there are many uncertainties in litigation which any party who has advised on or been involved in court process will be able to testify. But perhaps one thing which is certain is costs. It will cost. It will certainly cost more than making a complaint to a competition authority. There are interesting trends which are occurring in terms of opportunities for funding litigation, but again, changes in the rules may really affect the ability of a party to make its case. So in the UK, since 1st of April 2013, it's been no longer possible to obtain contingency fees in terms of actions before the UK courts, and that will be an issue for any private litigant, and that applies as much in antitrust proceedings as it does elsewhere. Evidence will clearly be an issue in private litigation, and the ability of a claimant to procure evidence will be heavily dictated by the procedural rules in the particular court. Where there are extensive rules on disclosure in one jurisdiction, those may not be replicated elsewhere. So there is a real question as to what a party can put before the courts to substantiate its case. The claimant will have the burden of proving its case. It may be able to rely on an infringement decision of a relevant competition authority, but in any event, it will have to prove causation and loss, and its burden will be so much more significant where it cannot point to a finding by a relevant authority that there has in fact been a breach. And it's there where we distinguish between a standalone action, which is not follow-on from an infringement, to the follow-on actions, which have formed a major part of the diet of the UK courts in terms of follow-on litigation. And a relative lack of expertise. It's important not to overstate this point, because judges, particularly in the UK, in Germany, are gaining much more experience in terms of competition litigation. But again, it has to be recognised that apart from unusual examples such as the Competition Appeal Tribunal in the UK, the decision maker, the judge, may not be a competition law expert. And that plays into the ability to make what can often be quite complex arguments in terms of law and economics. Turning now to the more practical issues. Again, since courage and Korean, a wide category of affected persons may bring a complaint or a claim before the courts. That may even involve the other party to an agreement which is the subject of the procedures that is being alleged as being anti-competitive or found to be so by a relevant competition authority. Where can the claim be brought is primarily an issue of jurisdiction in terms of the relevant procedural rules, but can be a question of strategy and deciding how to maximise the chances. It may be a case of launching multiple actions in different venues to increase the pressure on the defendant to settle. But it's not always the case that more is more effective, and a more strategic approach and selecting the right venue can be more effective. When can the claim be brought? There will obviously be an issue of limitation periods from when the cause of action accrued in these cases. But there will also be more complex strategic drivers, such as the likelihood of other claims being initiated by perhaps other customers who have been harmed by a cartel, and a claimant may find that it does not have the same flexibility in terms of choice of venue if it is required to join proceedings that have already been initiated by another party in another jurisdiction. Another issue is what law can apply. Generally, that will be the law of the country where the damage occurred. But again, when one's considering the substantive competition law, there are issues of whether the choice of law that's selected by the parties may supplant the relevant competition law that might apply should the case be investigated by an authority. There's recent authority confirming that, in fact, a choice of law clause can be overwritten for public policy reasons, where, for example, the damage is suffered in a particular country, and where on an effects-based approach, the law of that country should apply. What evidence is available? Again, the distinction between follow-on and standalone claims becomes highly pertinent here, where a claimant will already have had a significant part of their case made for them if they can rely on a relevant case of an authority finding that there has been an infringement. But again, the issue on finding of infringement and the extent to which the decision of that authority did in fact make findings of facts which can then be brought before a court will be one of the issues for the litigation. And finally, the issue on how claims will be funded. A striking feature of antitrust litigation in the United States has been the growth and sustained nature of the private action, where treble damages, 3 times the loss suffered, can be obtained, and that has fueled a very active market in terms of private litigation. The EU experience has been very much to compensatory damages, and while there has been examples of representative actions, these are by no means across the board and have had mixed experience. On the plus side, there has been growth in terms of third-party professional funders, and it's expected to be a growth area in the new regime. So just to highlight a few trophy jurisdictions which in the European Union have had some experience with a form of representative or collective antitrust action. Perhaps the most famous from a UK perspective is the replica football kit proceedings launched by a consumer body. They had the status of representative bodies and were able to bring such a case under Section 47B of the Competition Act 1998. Ultimately, that case did settle, but highlighted the limitations of what has up till recently been a form of opt-in system where parties have to elect to be part of the litigation. In France, again, there have been some examples of actions before the court. Again, mixed experience and perhaps not the proudest moments in terms of private antitrust enforcement, where failure to observe certain procedural rules, sending communications direct to email to potential complainants were grounds for rejecting complaints, despite quite active action by a consumer body. The Dutch system of mass settlement has been praised by observers of this area, and is perhaps one of the more successful procedural regimes which have allowed for redress based on antitrust harm in the Netherlands, and has been championed as one of the precursors to a more effective regime across the board in Europe. Turning now to the EU and UK reform agenda in terms of private actions. And it's probably fair to say this is such a developing area that by the time you are listening to this broadcast, it is probably the case that what is being discussed here has been taken over events reflective of this very dynamic enforcement area. Looking at the big picture from an EU perspective, it has been accepted since BRT and Sabem that EU competition law is directly applicable, and it gives rights to and produces direct effects in national law, which means that parties do have rights to bring proceedings in front of national courts for violation of their EU rights. Since the 1st of May 2004, the national courts have also been empowered to apply both Article 1011 of the Treaty on the Functioning of the EU and 1013. That's of particular significance because it allows the national courts to rule not only on whether there has been a restriction of competition, but whether there might be beneficial aspects of the agreement which fulfill the exemption conditions of Article 1013, allowing the national courts to take a much more holistic view of an infringement and relevant factors that may be called in aid by a defendant arguing that their practices did not infringe competition law. There are various safeguards to ensure consistency in judgments, whether by national regulators, courts, or the European Commission. So the national courts cannot adopt a judgment which runs counter to a decision of the European Commission in respect of the same matter. If a national court does have before it an issue of EU law that they believe they require clarification or guidance on, they can of course make a reference to the Court of Justice on a point of EU law. That has been a long established procedure, and it is not uncommon that cases which are not usually phrased in terms of competition law may involve competition law questions which are the subject of rulings by the Court of Justice. So that has set a landscape where in principle and in fact competition law claims have been possible and have in fact been made in the national courts. But this has been given real impetus by the European Commission's directive on damages for infringement. I'm not going to discuss each element of the directive in detail, but a few important takeaways are to be observed. One is the absolute protection of corporate leniency statements and settlement submissions. One of the challenges in instituting a regime for effective private enforcement has been the concern that the incentives on parties to apply for leniency before the regulators by disclosing their involvement in a competition law infringement would be blunted if those parties' submissions could then be brought in evidence in private litigation. So those are given protection under the directive. The infringement decisions by national courts, it was initially expected that those would be binding on national courts in damages actions. However, the compromise position is that rather than binding, those should be prima facie evidence. And again, the extent to which they will in fact be binding in the national courts in reality will be tested in individual litigation. But again, there was a concern that if every decision of every national regulator would automatically be accepted in the member state courts, that was going too far. A minimum 5-year limitation period for bringing an action for damages is the irreducible minimum. In the courts of England and Wales, we are now with a 6-year limitation period, and in front of the Competition Appeal Tribunal, which is much more favourable than the EU minimum. This is supported also by measures on the joint and several liability for damages amongst co-defendants, with some protection for leniency applicants. But again, the protection afforded to them is limited to the portion of harm for which they are to be accountable. And that's likely to give rise to quite interesting questions in individual proceedings. And the whole focus of this reform agenda was to promote collective type actions, and the Commission's recommendations in this area are a further step to establish some rules and norms of EU-wide application. The reform agenda also accepts the role of ADR and consensual dispute resolution, where these are the alternative options of resolving disputes, and in recognition of a much more complex enforcement regime. Turning now closer to home to the UK, which has certainly over the last decade or so been a very popular jurisdiction for bringing private antitrust claims when compared to European peers. And that's been for a number of reasons. One has been the specialist nature of the UK courts, with the Competition Appeal Tribunal, which is a specialist court for private actions. And since April 2013, the Competition Appeal Tribunal is now in a position to hear both standalone and follow-on actions, as distinct from follow-on actions, which were its previous remit. The High Court again may hear both follow-on and standalone claims. Jurisdiction, again, a very liberal use of the concept of anchor defendants, has allowed parties to launch litigation in the UK by focusing on a subsidiary of an undertaking that's been found to have infringed competition law. From a disclosure perspective, the UK is acknowledged as having much more extensive or favourable rules on disclosure relative to other systems, for example, in continental Europe. Damages are on a compensatory basis, but there has been recent litigation which has confirmed in the Cardiff bus case that exemplary damages may be awarded. From a cost perspective, a loser pays principal has meant that there are incentives to bring litigation. That has to be balanced with funding options, the role of conditional fees, and the ability to recover those from the other party in the event of success. And the UK has been proceeding at some pace with its own reform agenda in terms of UK litigation in competition cases. And we have parallel reforms of this year, which have now extended the jurisdiction of the Competition Appeal Tribunal to hear standalone claims as well as follow-on claims in competition cases. Fast-track procedures to speed up the process for simpler claims, expected to make the procedure much more friendly for small and medium-sized undertakings. The 6-year limitation period that applies in the High Court will now apply to claims brought in front of the CAT. So we have harmonisation on that aspect. There will be a limited opt-out collective action regime intended to give an impetus to collective type actions. This will be subject to a certification procedure by the Competition Appeal Tribunal to filter out cases which may not be suitable, unmeritorious. So it's intended to be a further check and balance in the system. Again, where the CAT considers that is just and reasonable. The role of settlement and ADR is also accepted in that regime. So where do we stand now? Is this going to be an opening of the floodgates in terms of private litigation in Europe, or is this no more than legislative panaceas? Well, in between those two extremes, I'm perhaps somewhere in the middle. It is undoubtedly the case that the initiatives at both EU and UK law will strengthen Europe as a venue for private actions, and particularly in the United Kingdom, which is already quite far advanced relative to other European peers. But there do remain a number of challenges for bringing private action. One issue will be the evidence that can be put before the court. The trade-off between follow-on and standalone actions again becomes pertinent in that instance. Damages, again, the way in which they are quantified, the amount of damages, the measure of damages will all be issues that the courts will have to grapple in. The UK, in legislating in this area, has chosen not to take any specific new approach in terms of quantification or causation issues. So the normal rules should apply, but we should certainly expect further litigation in terms of the types of damages that will be available and whether exemplary damages are available in particular cases. The standing of indirect purchases has been an issue that has been much debated at EU level, and this is the question as to whether a party further down the supply chain who has bought from a party who has purchased from the infringing undertaking may have grounds to sue, and if so, whom? It's put that if that indirect purchaser was unable to have the flexibility to decide on who they would sue, if they could not directly sue in their own right, they may not get sufficient redress or any redress at all for the harm they have suffered. And applying a compensatory principle has led the EU to accept the standing of those purchasers. The issue of indirect purchases has led to what has been neatly summed up as the passing on defence, and this is the issue as to whether a defendant, in response to a claim by a claimant for antitrust harm, may raise in its aid the argument that that claimant did not in fact suffer any loss because they passed on the overcharge in terms of increased pricing to their customer. So to use a quite domestic example, if there is a cartel in relation to the egg sector, and a supplier of confectionery cakes buys eggs over the competitive price as a result of this cartel, and then sues the egg suppliers, the egg supplier then raises the passing on defence, which is that the buyer confectioner did not in fact suffer any harm because any alleged overcharge they paid was passed on to purchasers of cake lower down the supply chain. So that is an example of how some of these issues of indirect purchasers and the passing on defence can raise quite interesting issues for litigation, and these will certainly be areas which will provide further hunting ground in litigation. Collective actions by name, we certainly have a recognised concept now. This has attracted a growth of a claimant's bar in the United Kingdom. Whether this will reach the levels in the United States is perhaps not likely, but again, it's important not to dismiss these important investments that have been made by firms from outside Europe who have shown their commitment to this jurisdiction by seeing prospects of advising parties in this area and drawing from expertise that they have in dealing with similar types of actions elsewhere, albeit under different procedural rules and different litigation cultures. Limitation periods, again, will be an issue, and when cases are subject to appeal, the extent to which that will drive litigation in the national courts. Perhaps the biggest issue is one around costs, and it will be interesting to see how more creative funding options are available and are actually utilised by claimants and defendants. And it is clearly an essential part of the decision on whether to make private actions as to how those are going to be funded throughout their duration. To conclude on a positive note, despite these challenges, there are signs of optimism in terms of developments which are conducive to a much more fertile private action arena. In terms of access to the file, EU law as it's such does not preclude a damages claimant from being granted access to certain documents on the file of a regulator, including the European Commission. But the question as to how extensive those rights are, the categories of documents, is subject to much more detailed probing. The case of Fleiderer and the Bundeskartelamt established that when a national court is presented with this question regarding documents on the national authority's file, there is no automatic rule either way, and there is a balancing exercise to be conducted. The European Court of Justice has affirmed that it is for the national court to make that assessment. How much of that reasoning will survive post-directive on damages remains to be seen, but there is clearly a tension that has been recognised by the EU legislature in giving this blanket protection to settlement submissions and leniency documents. Another area to watch is the development in the cartel decisions of the European Commission. Typically, there will be a time lapse between the Commission's infringement decision and the publication of a non-confidential version of the decision. Claimants in private actions will typically be seeking access to those decisions to the extent that they contain important information on the facts surrounding the cartel, which they can call in aid of private litigation. It's fair to say that the detail that has been disclosed in Commission decisions has become greater over the years. If that trend continues, it will certainly be of interest to claimants in private litigation seeking access to information that may assist them in a private claim. So at this juncture, clearly some developments to watch, and important to be in touch not only with the relevant law in this area, but how it's been interpreted, how vigilant the Competition Appeal Tribunal will be in the UK in certifying actions as suitable or not suitable for private litigation. I started this presentation reflecting on this area with a tongue-in-cheek image of a fairy tale castle. We've certainly moved on significantly from the vision of EU private enforcement as being a fairy tale. I certainly expect that in the coming years that this area will become more interesting and a much more realistic option for parties considering making private action, and that they will have the option and the ability to make their case in an environment which is more familiar. Thank you.